support and opposition. Senator Pan, any questions?
At the moment.
Any takers on public comment? Come on down.
Thank you very much.
I was going to say there must be a line. So if you'd identify yourselves before you speak, that would be helpful, and who you represent. And then I don't want to unduly limit conversation, but depending on the length of the line, I may have to at some point, but we'll start first.
Thank you, Mr. Chairman and members. Dan Keurig on behalf of the League of California Cities. We have an opposed unless amended position on the May revised proposal that you're discussing. First, I will say that we do appreciate a number of the changes that were made between the January version and this version. The withdrawal of the effort to undo the reentered agreements is something that's appreciated. There's also been, as was also discussed, there have been some long-standing issues with 2011 bonds and special pension rates and other things that there are proposals on, and those agencies that are affected are reviewing those aspects. And then it also would say there are some that we touch on in our issues document that I believe you have a copy of, and I've asked the sergeant to distribute an additional one. There's some other areas that we had raised concerns with, and it seems like there's been some movement that might be resolved in terms of clarifying. So we may be able to get there on some other things. All that said, there still remain, and Mr. Chairman, you did touch on what I think the three main issues are that apply to the broadest sweep of cities in the state. This first is, the first two issues are, there's been some discussion about interpretation of statute, that sort of thing. The first two issues I'm going to talk about have been interpreted. They've been interpreted by the courts, and in this case, the courts have, where we are, we're basically asking the legislature to not overturn the interpretation of the courts on these issues. The first issue is on the reimbursement agreement issue. When AB 1484 went through, there were a lot of sticks in that proposal. There was a lot of tightening up of the law and a lot of things that caused a lot of it really sort of tightened up things from a city perspective. But the legislature said, wait, there's going to be some incentives. There's going to be, if you kind of pay up on a couple of things, if you get your finding of completion, here are the benefits that we're going to offer you. And one of those is you're going to get your loan repaid. Now, the loans in the current law, it says that the oversight board is the one that determines of whether or not the loan was for a legitimate redevelopment purpose, and that's still the case. We've talked about moving to a countywide oversight board is the way the law is going to evolve. So those countywide oversight boards are going to look at these loan agreements and make a decision, look through the paperwork, hear the discussion, and make decisions on an individual basis as to whether a loan was or wasn't for a legitimate redevelopment purpose.
Well, why don't you tell me how a reimbursement agreement is a loan, and then give me the court case.
Yes, and I have.
Because it's not cited in your material.
It's the city of Watsonville, which is the vice mayor sitting right next to me here. Senator, there's two ways in our view, to make a loan. One is from a city standpoint with the redevelopment agency. One is the city gives the funding to the redevelopment agency, and the redevelopment agency turns around and does the project that is obviously connected to the redevelopment purpose, and then says to the city through some sort of contractual basis, we will reimburse you, and here are the terms, et cetera. We will repay your money at this. The other way is to say, well, look, rather than the city handing the cash to the redevelopment agency and then the redevelopment agency doing the work, the city says, we will use the funding to do that act. We will do it with just directly, condition upon you reimbursing us. So whether it's the cash goes and the work is done, or the work is done with the agreement to reimburse, we think it's basically the same thing. And with me here is the Vice Mayor of Watsonville, who the case was heard, I understand the Department of Finance is appealing it, but the judge walked through issues related to the reimbursement agreement issue and sided with the city of Watsonville that these reimbursement agreements were loans. So what we don't want to do is we don't want to go backwards on that in the law. There are many communities that when they went and got their finding of completion, they did so thinking that, oh, well, look, we'll settle up, but we're going to be able to get something. And now what you have here is, item number one is an effort to roll back what was offered from our perspective.
Well, tell me, were these reimbursement agreements, were they documented, and did they provide for interest on the loan on the use of government employees and government resources by the city on behalf of the redevelopment agency? What was the interest rate provided? What was the documentation? I'll read the city of Watsonville case. I'm a recovering lawyer, but I can still read. So why don't you go into that with me?
And at some point I want to turn it over to the Vice Mayor so he can talk about his specific issue. But it's our understanding is we're not looking for repayments of things that weren't documented. It's our understanding if there is a reimbursement agreement, it is basically a contract that would be written somewhere that would have the details on how much the amount is, when it's going to be repaid, and those sorts of things. And again, as I said before, the way the statute is structured today, the oversight board is going to look at these and, number one, decide it was a loan, and I'm sure they would look at the same things we're talking about to establish that, and two, decide it was for a redevelopment purpose. Maybe I'll turn it over to the Vice Mayor of Watsonville to talk a little bit about your situation.
So, do you want me to start from the beginning?
Well, we've got a lineup here, so what I'd like to do, I don't want to,
Right.
I appreciate you coming, and I don't want to interfere with your opportunity to talk to us about whatever it is you want to talk to us, but
Okay.
I'd like to concentrate, at least initially, on the redevelopment agreement issue and how you as a city structured your reimbursement agreement, and did it provide for some interest provision for, was there a cost to the redevelopment agency either than the reimbursement for labor and material? What does it provide for? I'm just trying to understand how we get from a reimbursement agreement to a loan in the traditional legal sense.
So I came after the redevelopment dissolution. I think, but one of the things that I was part of is when we were part of paying back, when we were asked to pay back the 4.4 million, we were told that it was going to be repaid. It was, from our staff, it was told to us that it was going to be repaid. So the council went ahead and voted on that. I was part of that council to pay back that money, but we were going to get it back.
Was it pursuant to, and did the city actually enter into a written agreement with the redevelopment agency that provided for, in essence, a loan of personnel, which cost the city money, and maybe provided for materiel, and how did that work?
Well, what did happen is that they said that we would get a notice, we would get the notice of completion if we did pay the 4.4 million. That was, believe that was written, and that's why we made that decision to pay the state, give the money to the state. But then afterwards,
I'm getting.
If I can help, I think what the Vice Mayor is referring to is the council, I think they believe what was represented to them by the Department of Finance is if they made their additional payments to get their finding of completion, if they settled up, that they would be able to get their loan repaid, which was the reimbursement agreement that we're talking about. So I think that's what the Vice Mayor's referring to.
Okay. I'll let you all continue. I'll try to stop interfering with your presentation. I obviously have questions, but I'll try to time them.
So if I can, just in the interest of time. So anyway, so this is a very big issue for our members. It affects a lot of our communities. And
How many cities are impacted by the reimbursement agreement?
Senator, we had 385 redevelopment agencies. We got 482 cities. We haven't counted every one of them. There's a lot of them that are out there, and I think you'll hear from some. I think the city of Ridgecrest is here. It wipes out what they thought they were going to get. I think the city of Fresno is in the audience. So there's a lot of cities out there that have this problem. We believe the courts have interpreted the law in a way that we think is reasonable, and we don't want to go backwards from that. The second thing is on the interest rate issue. Again, this was a statute the legislature wrote and the Department of Finance also wrote in 1484. And as was touched on by the legislative analyst, the question was, okay, the loans are going to be repaid, but what's the interest rate? People were looking around, what should the interest rate be? Well, as you all know today, from an interest rate standpoint, about the most bottom barrel interest rate you can possibly find is the LAIF rate. It's like 0.249 or something like that. It is a place where local agencies, treasurers put their money, not for in stock market or some investment purpose. It's a secure place with a modest level of return. So the thought is like, look, there should be some level of interest repaid rather than picking a number out of the air or taking whatever was in the contract, which in some cases, Senator, might have been higher than what people wanted to see. The thought was, look, if you put your money in LAIF, that's the return you would have gotten. So if you lent your money or contributed your money for some redevelopment purpose, that's fair enough in terms of the interest rate. So the courts have interpreted the second court case, and we have a representative from the city of Glendale here, is the courts have looked at that statute and basically interpreted the law is that the loan rate would be, the interest rate would be that LAIF rate over time. So this is another area of law of something that we believe was put in statute by the legislature. You had a bunch of sticks, and you said, here are the carrots. This is another place where this is being pulled back. And that is a big concern to local agencies. I would like to have Jillian talk about the interest rate issue.
Sounds like they're willing to talk about that, continue to talk about the interest rate issue.
Right.
Sure. Thank you, Senator Roth, Senator Pam, members of the committee, and staff. I'm Jillian Van Meiden. I'm the Chief Assistant City Attorney with the City of Glendale, and happy to respond to several questions as well as the interest rate issue. Glendale had about $71 million in loans and reimbursement agreements, and our agreements were principally for infrastructure purposes. So these are for our downtowns and the areas that were blighted and had not received upgrades to roadways, lighting, traditional things that are permitted. So we too, like most other agencies, either receive direct funding in the form of loans or through a cooperation and reimbursement agreements. And these were documented and these documents were provided to both our oversight board at the time of their approval as being legitimate. And something like 2 reams of paper were provided to the Department of Finance after that resolution approving the loans as being legitimate. So with respect to that issue, the LAIF rate issue is an interesting issue. In reading the statute, the job of the Oversight Board was to take a look at whether or not these loans were legitimate, and then the interest rate based on LAIF could be applied to the origination of the loans. As has been mentioned, the City of Glendale on March 16th of this year received a favorable ruling from the Sacramento Superior Court that our interpretation of the application of the LAIF rate was the proper interpretation under the statute. And that is that from origination, and that is at the time that these loans came into being, that the rate would be, the LAIF rate would be applied. Now that is a quarterly rate. It's controlled by a state statute. And so in applying that rate, the difference between the two, at least for the City of Glendale, is between $30 million in interest and about $1 million in interest. So the upshot for Glendale, and we're really one of the first agencies out of the gate on this issue, is how that rate is to be applied. In using the court's interpretation and in Glendale's interpretation, which has been upheld by the court, it is on a quarterly basis back to the origination of the loan. The average LAIF rate, we took a look at that last night to see what that was since 1977, which is the date, the earliest date of publication of these quarterly rates, is 5.61%, averaged over time. Yes, there were time periods where it went higher, and certainly time periods such as now where it has been historically low. But that average rate certainly can't be considered as exorbitant. So Glendale is just simply seeking the validation through this legislation that it is the historic LAIF rate that gets applied. For us,
It's a rolling rate.
which is a rolling rate and was
Would change.
It does change over time. It will float up, and it has floated down. As mentioned, it is historically low at this time. And this is where local agencies invest their funds. It's a prudent way to invest those funds with a reasonable rate of return. I believe the legislature was looking for a fair way to address some of the problems as indicated by the representative from the Legislative Analyst's Office, is that some of these agencies may or may not have been applying a fair rate to these loans. We are happy to accept the LAIF rate, but the devil again is in the details. How is that rate applied? And the way the statute governs LAIF, it is applied quarterly and it is compounded. And so that's simply what we did, and the court agreed. And so we're looking for some finality on that particular issue. And that issue goes together with the issue that we've discussed here already, and that is, what is the definition of these loans? You're seeing us here, and many of us here, because when redevelopment was originally authorized and under the Health and Safety Code, and I mentioned this the last time that I was here as well, agencies were encouraged to borrow money or accept financial or other assistance from the state or from the federal government or from any public agency for any redevelopment project within its area of operation, and may comply with any conditions of such loan or grant. So loan is a very broad concept under redevelopment. These were things that we did in good faith, relying upon, cities now relying upon the repayment for those cooperation and reimbursement agreements.
But as an assistant city attorney, when you had a loan at Glendale, how did you document your loan? Was it documented in the traditional way that you would document a loan in a commercial or private setting?
They were documented through resolutions that were adopted by the city and by the redevelopment agency, and then with actual agreements, so we have cooperation and reimbursement agreements. And I referenced this. We provided that documentation
Right.
to the department.
Which I think may be the finance department's concern, looking across the 400-plus cities and however many redevelopment agencies we have in the state of California with these. I want to get to the interest rate in a minute, but with these reimbursement agreements, how do they sort through ones where they are fully documented in resolution and by written agreement, where you have a loan of personnel and services and material that's quantifiable, that you then document, and the redevelopment agency agrees to repay the city for that loan of people, money, and material, from those that perhaps aren't documented quite as well, and how do you sort that out?
One thing I would say on that, Senator, is really what's the intent of the legislature? I mean, if you have the documentation, this bill today undoes what the city attorney was talking about. And it clearly sounds like if you've got, as you said, some reams of paper that support this, clearly that loan shouldn't be undone by this proposal. Again, as I said before,
I might agree.
we are not supporting anything loans that are not documented, or someone saying they had a loan and there's no paperwork. We're not talking about that. We're talking about agreements, which means a piece of paper somewhere that has probably an amount, some terms, and it's documented, whether it's by resolutions or other written things that a judge and an oversight board is going to recognize as legitimate.
Well, let me move to the interest rate issue. I mean, I understand the argument that you're entitled to. I mean, I understand that before I came here, that there was a dissolution process and that invalidated agreements, and that's what finance says, and I'm not going to contest that, but there is, your interest in getting a reasonable rate of return on your investment or the money that you've loaned. What would be the problem in taking a look at this floating LAIF rate issue. I understand redevelopment dissolution, I think, and that your position is the agreements were invalidated, and maybe the statute's clear on that.
Well, I think the main problem with going with the floating lake rate is contrary to the statute as we interpret it. We believe legislative intent was to not have a floating lake rate, but to have a fixed lake rate. And they have one lower court ruling in their favor, and we're going to appeal that, and we'll see where the chips may fall on that. But we don't agree with the lower court ruling, and we respectfully disagree with the City of Glendale's interpretation of statute on this point. All that to say that we are, as we said before, open to discussions with people on a happy medium ground on this issue. Right now, we're proposing a 1% and a 2% rate, respectively, depending on what sort of payment schedule you're on. And if people want to come to us with an alternative recommendation, that's we'd be happy to listen to that.
Well, I think I probably said this before. I certainly don't want to do anything to interfere with a pending court case, so I assume that whatever we ultimately do here would not, and I need to make sure of that, does not interfere with the Glendale versus Department of Finance case. If it's on appeal and if the appellate court decides that they're right and you're wrong as to the application of the interest rate, then I would certainly want to make sure that we comply with the Court of Appeal decision. But having said that, I cut some people off. Anything else here? Ma'am, were you finished?
I just wanted to add one more point, and I think it's important in terms of the recognition by the state of the concept of the advances and the loans. In the Community Redevelopment Agency annual report by the State Controller's Office, it makes reference to the total amount of outstanding indebtedness between the cities and the counties for loans and advances. So there was a statewide recognition that this was the process. It wasn't just cash loans. It involved advances of funds or other services as authorized under the Health and Safety Code. So I think that we'd be well served if we could recognize and respect where agencies were coming from in good faith in terms of cooperation and reimbursement and loans on a going forward basis, and not slice the definition so thin as to compromise cities' ability to now repay their general funds. And Glendale's general fund is definitely hurting, and I know you will hear from that. We will be going into deficits. We will be in several years, maybe up to 5 years of deficits. We've cut everything but core services. So the impact to us is very real. It's very visceral, because now we're looking at the largest component of our budget, which is health and safety. And we feel very strongly that there are winners with this revised budget trailer bill, and there is much benefit to those individual entities, and there are a few. But for most of us, in Glendale in particular, the impact will be directly on health and safety services. So if a fire engine can't have 4 people on it, they can only have 3. It's a very real possibility that lives could be lost. If the fire department or the police department have to cut sworn officers, that's our concern. We're happy that cities like San Francisco will have the ability to address a much-needed affordable housing crisis, but we also have affordable housing money that we will lose if we're not able to repay these loans, 20% of which were to be forwarded for low and moderate income housing.
What's the amount, total amount?
So the total amount would be $8 million if Glendale's interpretation stands, and if all the loans and reimbursement agreements are considered valid, and we believe that they have been twice legitimized by our oversight board. That would be reduced to something less than $1 million, maybe $700,000, and actually less than that, because we have received one payment from on our ROPS towards this loan. If the department's interpretation stands, the total repayment Glendale would receive would be $2 million, 1.5 of which has already been repaid, leaving about $700,000 left outstanding if the department's interpretation stands.
So let me make sure
I know I
so the
threw
total,
a lot of information out.
That's okay. I've got a simple brain here. So the total amount at stake for Glendale as a city is $8 million, and you've already been repaid $1.5 million.
That would be, the 8 million is 20%. So the total amount outstanding for Glendale, principal and interest combined, is roughly $45 million.
And what's the impact of this LAIF rate being up to 1% versus LAIF rate in effect over the life of the loan? What's the delta we're talking about here?
$30 million.
So it's $30 million. So
Yes.
if you have LAIF over the life of the loan, it's $30 million. If it's LAIF at current rate up to 1%, it's what?
Roughly $2 million.
So this $30 million delta.
Yes.
Okay. What's your total budget?
Oh, there's someone else here who can address that issue.
Okay.
From Glendale. Thank you.
Okay. Sir.
My name is Jack Aginian. I'm the mayor of the city of Montebello. Unless amended to remove all provisions that are harmful to local governments, the city of Montebello continues to oppose the governor's budget redevelopment dissolution proposal. This proposal continues to prevent reinstatement of all but a small percentage of loan agreements between the city and its redevelopment agency, and revokes a promise made by the legislature to cities that have complied with dissolution mandates. This change would cost the city of Montebello over $4 million.
And is that for reimbursement agreements? So the city has provided services. So employees, labor, material to the redevelopment agency for which you are not going to be reimbursed?
Yes,
And that's $4 million?
$4 million.
Were your reimbursement agreements documented in the form of written agreements between the city and the RDA?
They were.
Okay. Did they provide for any rate of return, any interest on the dollar value of the services provided to the RDA by the city?
I can't answer that question.
Okay.
Also, this proposal significantly restricts the ability for communities to seek judicial review of Department of Finance determinations by exempting the Department of Finance from compliance with the Administrative Procedures Act and eliminating litigation funding for successor agencies. These changes would virtually immunize the Department of Finance from oversight. This proposal reduces funding to successor agencies that are working to wind down the affairs of their redevelopment agency by precluding funding for property maintenance expenses and other costs and retroactively invalidating loans made by a city to assist the dissolution process. We strongly support the property tax override provisions, the selective provisions of the proposal that would require revenues of voter-approved pension taxes to be allocated to the levying entity. This is a much-needed revision to the law required to fix unintended consequences of redevelopment dissolution. In Montebello, this amendment would provide over $3 million annually to fund pensions for public safety employees, specifically police and fire.
The APA, the Administrative Procedures Act issue, sort of fascinates me, but isn't this whole effort on the part of Department of Finance to put a period at the end of the sentence, in other words, to wrap this thing up? And I understand the Administrative Procedures Act conversation, but I'm just wondering, isn't the horse out of the barn here, and aren't we talking about the end of the process? And if we were going to be talking about APA, shouldn't we have been talking about that at the time when a variety of these interpretations and decisions were made? I may agree with you, but isn't it sort of too late to be talking about that?
I think there's some validity to your point, Senator. I mean, it's been 3 or 4 years since the dissolution process, and the legislature probably should have established a more robust accountability process. But here's the reality we're living in. I mean, you talk about a period at the end of the sentence. I mean, clearly it's probably in the Department of Finance's interest to put a period on the end of the sentence. But I would say for legislators who actually want to make sure that the affected communities are able to access due process, I would say that you should not be willing to put a point at the end of this period right now. The way the process was structured, and as we all know, the bills were written in a chaotic environment at difficult times, but there was no accountability process that was set up for the Department of Finance. They were giving very broad flexibility to make, we've talked about contracts here and things involving property and money. They were empowered to make many quasi-judicial decisions without really any real established structure.
But focus. I wasn't here. So
Right.
focus me right now. This is 2015. 2015. We're rolling into 2016. I understand the administrative process and the Administrative Procedures Act and the need for regulations when interpretations are going to be ongoing and all of that, but aren't we at the end? And that's why I don't want to particularly, I don't know whether the APA is really the focal point here. Aren't we sort of at the end of the process, and by the time regulations are put in place, assuming we adopt an APA requirement, isn't most of this going to be over, and what are we doing?
On that narrow point that you're making, Senator, I'm not going to disagree with you that this is 3 or 4 years too late to be focusing on this. However, this is a twofer. This isn't just trying to kind of clean up the books and say, oh, by the way, we never had to comply with the Administrative Procedures Act. The other part is the only chance we had, the only due process that was afforded to us in the statute was to be able to, at some point, if we felt there was a problem, such as the city of Glendale had, such as the city of Watsonville had, their only place for some sort of neutral, fair hearing was Sacramento Superior Court. That's the way the legislature set it up. So if you're going to have due process, clearly you have to be able to afford an attorney to be able to represent you in that forum.
So focus on that. So I asked the finance this issue at the beginning of this process. So I don't understand your point, the point about litigation expenses in your memo here. So would you focus on that for me?
Thank you. So the way the legislature and the administration wrote the law, they basically said, look, cities, you guys will have a chance to have due process. We'll set up this thing at the Sacramento Superior Court. That's the way, if you want to appeal, you'll have your day in court. That's where it is. And then for litigation expenses, it specifically said, in no uncertain terms, that the cost of litigation that would support the due process on behalf of the successor agency would be covered as part of the cost of doing business as an enforceable obligation. It was the price of due process is having a chance to be represented in the courts.
We haven't impacted the Superior Court right, correct? This proposal doesn't impact that.
It's gonna for those. Well, so the proposal right now has changed to you can't have any legal expenses on as an enforceable obligation to say, oh, it all has to be under the administrative your limited administrative pot. The one change in the May revise says, oh, a city could loan money to the successor agency. Well, there's a lot of cities around this state that don't have a lot of money. I mean,
no. Let me just. Let's get to my question here first. This proposal does not change the right that a city has to go to Sacramento Superior Court and litigate Department of Finance decisions, does it?
It doesn't change the right, but it certainly undermines their ability to do so.
Okay, now, so that's point one.
Right.
Now let's focus on my question, which is point two, which apparently has to do, maybe the Assistant City Attorney can help us. Point two is there's some issue, which I'm trying to figure out what it is, that has to do with the ability to recover legal fees and expenses. And I understand the original proposal would have interfered with that. This May revision, as I understand it, allows the recovery of attorney's fees and costs to the prevailing party, which could be the city, in litigation in Sacramento Superior Court over DOF decisions, right? I mean, I just want to make sure we're still on the same page as to what the proposal says.
Yes. Well, okay, so I'll try to be extremely brief here. Existing law says you can recover, if a successor agency is pursuing due process, they can recover their legal expenses as part of an enforceable obligation. No argument about it. The original January version of this proposal said, we're striking that out, you can't do that at all, and if you have any litigation expenses, you've got to somehow absorb them in your administrative cost cap, which is extremely narrow, and it's being constricted in other ways by this proposal. So they were cutting, no, they were cutting off or constricting the source of the funding for litigation.
I understand that.
And then the amendment that was made in January says, oh, if somehow those constrictions don't allow you to do something, a city may loan you the money, and if you prevail, then there's a process to try to get it back. So we've gone.
It's not try to get it back. You get it back, right?
Well, I don't know. You've heard all the arguments in this room about.
I mean, you've read the language. What is it? Do you get it back? Or
Well, we have some suggestions about maybe how to tighten that language, but I mean, there has been discussions among the attorneys that have looked at the language that have questioned whether or not there'll be another argument about with the Department of Finance about what prevail means and other things like that.
Well,
So
come on. Lawyers who practice in court understand what prevailing party is. It's commonly applied. Judges commonly apply it to determine who gets fees and costs. I don't buy that as an argument. Now, if there's language that calls into question whether the prevailing party gets to recover attorneys' fees and costs, then let's talk about that. So is it the fact that the recovery is limited to when you prevail that's at issue for the league? Or is it the language?
yes, I think it's your first point. I mean, we've gone from a legislative construct that allows these affected successor agencies to be able to have an access to due process in the forum that was created by the legislature, which is Sacramento Superior Court. This bill, if it's enacted, will limit the access to only those that figure out a way, if they have enough funding, which could include the financial condition of their city. And so it is reducing, there's nothing in this bill that limits the ability of the Department of Finance and the state to protect its interests in Sacramento Superior Court. This proposal is all about limiting our interest to protect our interests in that same forum.
So would you agree to a general prevailing party rule, which is if the city prevails, it gets its fees, and if the state prevails, the state recovers its fees and costs from the city?
I guess what I would ask is, why is the legislature even considering removing such provisions that harm our interest to access due process? I mean, we've talked about a process already that, as we said before, the Administrative Procedures Act, it would have been nice if that would have been applied. We all know that hasn't been applied. So we're operating a process that doesn't have a lot of rules. The only place you can go is the court. And then it's a twofer here. One, we're making it clear that the Administrative Procedures Act doesn't apply. Okay, fine. And then secondly, we're saying we're going to constrict your ability to protect your interests in a court of law. And we just don't think that's fair, and we just don't think that's an appropriate proposal. We think that these agencies ought to have a right to protect their interests, just as the state has, and the structure the legislature established shouldn't be undermined.
Well, I just wanted to make sure I clearly understood what the beef was, and I couldn't clearly understand it, frankly, from your memo. And so the beef is that we're going to a prevailing party recovery system for attorneys' fees and costs if you litigate against the Department of Finance in Sacramento Superior Court, which is different from the way it was prior to January 2015.
Right, and your point is acknowledged that it's only a prevailing party for one entity. The Department of Finance's ability to have whatever resources it needs continues.
Well, you probably prefer that. You probably would not want to be paying the state's legal costs if the state wins, however infrequent that is, right?
No.
Well, you answered my question. I didn't understand. Is there any?
In the interest of time, there are other issues in there that we've touched on. I think these are the three main issues that are the broadest applicability, and that's why. And I appreciate the time you've given us to focus on them. Thank you.
You want me to
Senator Roth.
a little bit about?
No.
Would I be able to say a little bit about the background of our
Sir,
city?
you can. This is consistent with the fact that I've got a few other people who want to speak too. I don't want to cut anybody off. I appreciate the league's engagement with me. Thank you for your patience, sir.